Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
And welcome to our show. Thank you, Michael, for the introduction. Well, it's 2016 and we're starting our new season here at Naples Daily News, and I'd like to welcome our first guest this year, or really it's our second guest, sorry Don.
Second,
Bobby Clampett was on our show last week.
Well, that's good.
PGA pro. But again, I know we do the legal tip every month, but for the viewers that have not seen you before, can you just give us a little background about yourself?
Sure. I'm an attorney. I've been a member of the bar since 1983. Tax degree, real estate attorney. I have my own title company, Ross Title and Escrow. I'm one of the shareholders and an attorney for Downing Fry Realty. I've been the attorney for Downing Fry for about 25 years. Staff of about 8 people for the closings, and we're on 41, the corner of 6th Avenue North and 41.
Great, that's the Capitol building?
The Capitol Bank building, correct.
Well, Don, we're here today, I think, to talk about foreign people that buy property here in the United States, and I'd like to maybe start with maybe the things that really they don't understand, because their laws and real estate is different in their country compared to our country. So when we have a lot of foreign investors buy here, so maybe you could start off with that, where you think we should start off at.
Well, I think they should know that there are tax ramifications on how they hold title to the property. That if they buy and sell real estate in this country, they very well could be subject to capital gains tax, income tax. If they pass away owning a U.S. real property interest, it could be subject to a state tax. So it's very important for any non-resident, it could be Canadians, it could be anybody from any different country other than the United States, to, after they sign their contract, speak to their Canadian attorney if the case is that, and a local attorney to determine what's best for them.
What happens if they've haven't seen the show, okay, or weren't familiar, and they already have title in this, and the property's already titled, and they've closed on it, and what do they need to look at or change at that time? They
should talk to their Canadian attorney to see what the ramifications are if one of them passes away or if they sell the property. A lot of variables go into what would be the best way to handle that. The person's net worth, their age, whether if they have it in corporate form, whether they have any losses they can use, their health, a variety of issues. What I try to do when I have someone on the phone asking me how should I hold title on, both for income tax and estate tax purposes, because sometimes they conflict, honestly. I'll use myself as an example and say, well, if I were buying in Canada, again using Canada as an example, and Canada had the exact same statutes that the United States has, here's what I would do. And I'd tell them my age and my health, and I would do it this way, and I assume I would sell it in 5 years, and I'm not planning on passing away in the next 5 years, so I might do it this way. So if it's a small deal, you might be more apt to put it in an individual name and just get some life insurance. If it's a multi-million-dollar deal and the people are going to hold it forever and they're 70-something years old, they might want to do something different.
Okay. Well, let's take it, that's the first step. The second step would be contracts, okay? So maybe you could explain, if you're working with a foreign person, how the contract maybe would affect them.
Well, the main thing I do, again, I'm the attorney for Downing Fry, so I encourage all the agents to call me 7 days a week. They have my cell number, they can call me. And if you're showing property on a Saturday or Sunday and you have somebody who's read a little bit, and that's the ones that are always dangerous. They've read a little bit, and they know about the withholding tax on dividends and interest, which can be 30%, to be concerned. So I tell the agents, call me, and I'll get the person on the phone. And if it's the Naples Board of Realtor contract, I tell them, well, this is assignable. It is assignable. So it's okay to make an offer if you're trying to grab that property.
Okay.
And is that my phone? Yes, it is. So make your offer. Make sure it's assignable if it's NABOR. If it's FARBAR, they have paragraph 7 in the as-is contract where you can assign it and be relieved of liability, assign it and not be relieved of liability, or not assign it. But the big thing is it assignable?
Okay.
And talk to your Canadian attorney, who will call me or some U.S. attorney.
Okay. So after they figure that out, how about transferring the funds down here from a Canadian?
Everything's wire. That gets into fraud issues.
Right.
This is a very wealthy area, as
That's
we all know. And of course, all the scam artists are attracted to where the money is, and that's here again. I've had cashier's checks from Nova Scotia banks.
Right.
I've had emails from people in various foreign countries. I've had forged checks from, actually it was Chase Bank in Maryland, and it was supposedly from a dentist in the UK, but his identity was stolen by somebody in Nigeria. So you want to wire the money.
Right.
And what I tell my people, let's say we're going through the closing and it's getting time to disperse to the seller. If the wire instructions change, call the person, because what we have is people will hack into a string of emails,
right,
and not do anything until it gets to the end of the transaction where the seller is about to get their proceeds,
right,
and impersonate them and email us and say, send it here. So
right,
we call and say, did you send us new wire instructions? No.
right.
And then you really have to be hyper alert. It's incredible how inventive some of these people can be.
Okay, Don, we're going to take a little short break, and we're going to be right back in 1 minute, and we're going to continue this discussion on foreign investors or foreign people that just buy property here in the United States.
Thinking of buying a home located in a golf course community in the Naples, Marco, Bonita, or Estero, Florida? Here is what Mark Lai, former PGA winner, says about Realtor Michael York of the York Real Estate Group of Downing Fry Realty.
Hi, I'm Mark Lai. If you have any real estate needs in Naples, Florida, the one company to contact is the York Real Estate Group. Also, if you want a golf course property to invest in, Michael York of the York Real Estate Group is the guy to contact. Michael knows every golf course in Naples. I will tell you this, he's been in the golf business for a long time. He's played all the great golf courses down here, and he is an outstanding realtor. I've known him for quite some time, and he's he's got a lot of integrity, and he very much knows his stuff on all the different clubs here in Naples. So the York Real Estate Group is a great place to start. So if you have any time or anybody that wants to visit down here in Naples and look at the options out there, please contact the York Real Estate Group.
Welcome back. Don, I think next month, when somebody sells a property, the government has changed the laws here for foreign people that are selling property.
Right.
Maybe I did a column today in the newspaper that was explaining a little bit about this, but the people that didn't get the opportunity to read the newspaper, maybe you could explain what I wrote in my column.
Well, this goes back to 1981 when the Foreign Investor Real Property Tax Act was first passed. I was in tax school in 1983, so we were studying it 2 years after it was passed. And at that point, what we were trying to do, or what the government was trying to do, was to make sure that when a non-resident sold anything in this property that was a U.S. real property interest, and real estate generally is, unless it's held a certain way. You have to withhold 10%, send it into the IRS. Of course, that prompts the inquiry from the seller. What is this? I'm not selling it for a profit. How do I get my money back? This is outrageous. And then I explain to them, the point of this is to force you to file a return and pay whatever tax is due, the same tax that Jim York would pay or Don Ross would pay if they bought it at this price and sold it at the same price. So the whole theory is generated by the purchase of very prominent real estate in New York by the Japanese in the early 80s, was just to force people to file returns and pay their fair share, just like you or I. After all, if I sold something in Canada and they just gave me a check, I'd come home and I'd put it in the bank, and I wouldn't be calling the Canadian Revenue Authority and asking, do I owe them any money? I just, unless somebody told me or took money up front, I would not go further than that. December of 2015, the President passed into law protecting Americans from tax hikes. When I read the title, I was like, what does this mean? It seemed a little ironic, hardly possible. But what it does is it bumps up the 10% to 15% for the disposition of a U.S. real property interest by a non-resident. And that's the phrase from the code. So it's kind of offensive. They refer to them as non-resident aliens.
From Mars.
From the Internal Revenue Code. So anybody from a country other than the United States, non-U.S. citizens or residents, will now have to withhold 15% and send it to the IRS, and then they file their tax return. They may or may not get money back, depending upon whether they had a gain or not. There are exemptions, okay? The $300,000 exemption is still there. It was in 1981. It will still be there, and that is for people who are, if the buyer is paying $300,000 or less, and they're going to occupy the premises at least half the time it's being used. So if people are physically in the house 2 months a year, will the buyers or the buyer's family be there 1 month and a day? Is that their plan? And these could change. It's okay if someone gets sick or they have financial reverses, they can all of a sudden decide we have to do rentals because we lost our job or whatever the case might be. So if that situation exists, the buyer can sign an affidavit saying, yes, I intend to use it at least half the time it's in use. Now, I get asked, why? I mean, that doesn't make any sense. Why should there be an exemption for that? And the answer is the National Association of Realtors was very powerful, still is, 1981, and that covered most of the deals in the country, and they didn't want them disrupted, so they got that. They bumped it up now to $1 million, and there are no regulations on this law yet because it was just signed in December. So most professionals are assuming that the $1 million exemption, which reduces the 15% to 10, will follow the same rules as the 300,000 exemption. Okay, so if the buyer is buying a place for $750,000 and they have the intention of occupying it at least half the time it's in use, the buyer would only have to withhold 10% instead of 15% and send it to the IRS. And the thing that people don't get is this is a legal obligation of the buyer. The U.S. government has a security interest in the property if it's not done, so you don't want to get cute and try to circumvent the law. There could be criminal implications. Agents can be liable if they engage in conduct or some sort of scheme where they get around this and they know it's essentially lying to the government. Closing agents, could be liable as well. So that is the new law. The most common way we avoid this withholding, I think people just sort of forget, is our standard seller's affidavit. I mean, it says a lot of things in this affidavit, but one of them is that the seller is not a foreign person. Here's my Social Security number, and therefore there's no withholding if they're a resident. So that's path. It's going to be interesting when the regs come out. Hopefully they'll mirror the existing regs.
So just I know you explained a lot here, but
Too much, huh?
a little, maybe not, but up to $1 million on a sale, how much would they withhold?
15.
15. Up to,
It's 15 for everything,
Everything.
but then you have to qualify for an exemption. There's
Right.
one exemption to knock the 15 to 10.
okay.
And there's another exemption to get rid of it altogether,
That's
and that's
right.
300 or less.
And you can do that before you purchase the property or during, so you don't have to withhold that at the closing, right?
Actually, how it mechanically works is
Uh-huh.
once you have a signed contract, the seller hires somebody to apply for a withholding certificate,
That's
it's called.
right.
The
Yep.
82, 88B, I think you referred to in
Yes,
your
I did.
article. It's a withholding application for a withholding certificate, and you want to make it as simple as possible. Here's the closing statement for when I bought it.
Right.
Here's the sales
Sale
contract for selling it. I'm not making any money. You got to make it real simple, in my experience. And the money is still withheld, but it's held by the title agent, and the IRS is supposed to respond within 90 days.
Right.
It's supposed to. I have had them respond by saying, we need more time. I've had them not respond at all. But once the IRS responds with hopefully, yes, you don't have to send in the whole 15%, just send in, you don't have to send in anything because they sold it for a loss, you can give the money to the seller.
Okay. Well, Don, we're going to take another little short
Sure.
break, and we'll be back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, let's kind of finish up our last segment here.
Sure.
Is what can somebody do to plan to avoid a lot of mistakes or taxes or whatever?
Back to what I said earlier, the most important thing is this assignable? Is this contract assignable? Because you show properties evenings, weekends, things
That's
like
right.
that. And if they're buying something, and they're not sure, and they've read about it on the internet, they need to feel safe. They need to be safe. So again, NABOR is assignable. FARBAR, it's paragraph 7 in the as-is contract. You can assign being released, assign not being released, one of those two. If the seller doesn't want, or if the seller doesn't want it to be assigned, you can write in language, have me review it or some lawyer review it, that it's assignable to a wholly owned entity by the buyer. That usually calms down the seller, or related to the buyer, because it might be a trust with various family members in it. And then you can make your offer. So it's step 1, you have to get the property.
Right.
And you have to have the flexibility to maneuver. And you might very well decide just to keep it in husband and wife. You might be 50 years old, good health, been married a long time, everything's good, and you can buy a life insurance policy that would cover any potential tax if you get into a tragic accident. That's if somebody's that young, I say that's the option, because the client is the business person. They make the business decisions. I just give them options.
That's right. Yeah.
And some of these options cost money. If you have to form trusts or partnerships or foreign corporations, you got to pay the lawyer to prepare them. You have to, there's usually annual fees, there's tax returns that have to be filed on an annual basis, so there's a cumulative cost, and the client has to be the one who measures, risk reward. Is this cost worth this? I'm 50 years old, I'm healthy, I'm probably going to sell it soon. Older clients, and if they're buying something more expensive and they're extremely wealthy, the next step obviously is, again, calling your U.S. attorney and calling your Canadian attorney. I almost always, again, we're using Canada as an example here, but it applies to all the different countries. I I always work with an attorney from another country all the time, because I don't know Canadian law. I mean, I know bits and pieces, what I've read in articles, but I am not an expert in Canadian law. I'm not a Canadian attorney, and they're not a Florida attorney. Exactly. So, and having the tax degree helps a bit too. So we'll coordinate, the Canadian attorney will look at the Canadian implications, tax-wise, if they sell or pass away, and we can look at the U.S. implications if they sell or pass away, and we factor in age, health, net worth, all those variables, the costs of operating whatever structure we come up with, and give it to the client. But there are, again, simple methods. Insurance, because that's not considered a U.S. asset for estate planning purposes. Non-recourse loans, you see that sometimes from Canada.
That's right.
Because the estate tax is imposed upon the net fair market value after the mortgage. So if you can wipe that out, you can do that. And of course, we have a treaty with Canada on tax matters, so that we can. They attempt to avoid double taxation. Okay, they make that effort, and they reduce certain withholding taxes on interest, dividends, the sale of proceeds. We used to have the possibility of having a Canadian corporation own the property, but you had to watch out for single-purpose entities. If the sole purpose is to own the real estate, you used to be able to do that. Now you can't in Canada. Canada changed their laws. Now I see more of partnerships, trusts, where the trustee is a Canadian attorney and the beneficiaries are the purchaser's children. If they're that wealthy again. So it can get really complicated, or it can be real simple. A 50-year-old, husband and wife with some life insurance buying a $500,000 home, they should be fine. But they need to talk to their attorneys, and there's going to be 2 of them.
I agree with you. Well, Don, thank you for coming on the show.
Thank you for having me.
I'm sure this has been very helpful for people that are purchasing property or own existing property here in the United States. And
Hope so.
I look forward to next month with you on the
Thank
legal
you.
tip, okay?
Okay, Jim.
Thank you very much.